227 Presumptions. To govern when a key term is vague. 1. An interpretation that a promise is an unconditional duty is favored when the event necessary to fulfill the condition is within the obligee's control. Our second 227. 2. 2. An interpretation that reduces promise's risk of forfeiture is preferred, unless the event is within the obligee's control or the circumstances indicate that he has assumed the risk. Our second 227. 1. 3. When in doubt, a promise should be interpreted as an unconditional duty. And 4. An interpretation of a term as both a duty and condition is very unusual, and will require some special language such as, buyer's obligation to pay is expressly conditioned on arrival of the package by 3 p.m. on Wednesday, and seller is obligated, and will be liable in damages if the package is not delivered as specified. Conditions precedent preferred an interpretation, where an event is condition of an obliger's duty is preferred over interpretation under which the non-occurrence of the event will be a ground for discharge of a duty, after it has already become a duty to perform. Condition subsequent. Step 3. What counts as a satisfaction of the condition? Objective standard. Generally, occurrence of the condition, that a party be satisfied with the performance should be based on whether a reasonable person in the party's position would be satisfied. When to use OS. When it is practicable to determine whether a reasonable person in the position of the obliger would be satisfied, the objective test should be used. When is it practicable? Usually, in cases of commercial utility, it is practicable to use the objective standard, because the interests of the parties are usually practical or technical. When is it not practicable? When the essence of the performance is aesthetics, then the subjective standard should be used, because the parties' interests are more personal and aesthetic. 228 Subjective standard. Personal taste clause will allow the obliger to be entitled to terminate all further obligations under the K if she, honestly, if subjectively, did not like the work. Good faith is required. Even when the subjective test is used, the party still has an obligation to act in good faith when determining if the performance is satisfactory. Ask, did they make an honest decision, or were they motivated to reject the performance by malice? Step 4. What are the remedies? Pure promise. Breaking a promise will result in a breach of K action for damages, but the K will still be enforceable. Pure condition. Non-occurrence of a condition will make the K unenforceable, but there is no liability for damages. Promissory condition. The non-occurrence of a promissory condition will make the K unenforceable and create a cause of action for damages. 225. Effects of non-occurrence of a condition. 1. Performance of a duty subject to a condition cannot become due unless the condition occurs, or its non-occurrence is excused. 2. Unless it has been excused, the non-occurrence of a condition discharges a duty when the condition can no longer occur. 3. Non-occurrence of a condition is not a breach by a party unless he is under a duty that the condition occur. Step 5. Are there exceptions? 229. To the extent that the non-occurrence of a condition would cause disproportionate forfeiture, a court may excuse the non-occurrence of that condition, unless its occurrence was material, plus in addition, also by hindrance or wrongful prevention, when a party's duty is conditioned on an event, and that same party's wrongful conduct prevents the occurrence of the condition, the non-occurrence of the condition will be excused, and the party still has to perform. By acceptance, if a party retains benefits under a K after learning, or having reason to know, that a condition of the K had not been met, he will be held to have waived the condition. Illustration. Our second. 227. 1. GC/SC drama case says pay will be due 5 days after payment to GC by developer. Developer never paid GC. More than 5 days have passed since D was supposed to have paid GC. D says it will not pay until D gets a chance to inspect SC's work. Nothing in the contract says anything about that. GC is still liable for SC for the due. KF. Appenhema v. Appenheim. Unless and until text in contract meant no substantial performance. Breach. Step 0. Is there a breach? 235. Any failure to perform when that performance is due is a breach. Order of performance. A. Simultaneous performance. When the performance is to be exchanged under a K can be rendered simultaneously. Presumption that parties intended them to be performed simultaneously, and they are therefore due at the same time, unless K provides otherwise. Concurrent condition. Simultaneous performances are considered to be concurrent conditions to the other party's duty of performance. B. Subsequent performance. When one of the performances requires more time than the other pair, often remains longer performance is due before the shorter one. C. Divisible contracts. When a promised performances can be divided into a number of part performances, the other party is required to perform their respective duties, as if there were a number of different Ks. Those constructive conditions can be negated by express language in the contract that provides to the contrary. 238. Effect on other parties' duties of a failure to offer performance. When unperformed performance duties under a bilateral contract can be performed simultaneously, both parties must establish a willingness and ability to perform. Once tendered, their performances are due at the same time, since the exchange of payment for goods can be done concurrently. O. Stating that one is willing to proceed with a deal, willingness, and showed the check, ability to perform, will fulfill the constructive condition. Step 1. Define which type of breach. 1. Partial. Technical breach must keep performing, but may sue for direct damages. 2. Material breach may suspend performance. Suspended animation must notify other party of suspension, must give reasonable time for cure, may turn into TB. 3. Total breach completely discharged from further performance, may seek all remedies. Step 2. Does that count as a material breach? 241 Material breach circumstance is significant in determining whether a failure is material. A. Extent to which injured party will be deprived of the benefit he reasonably expected. B. Extent to which injured party can be adequately compensated for what was deprived by partial breach damages. C. Extent to which party failing to perform, or to offer to perform, will suffer forfeiture. D. Likelihood that party failing to perform, or offer to perform, will cure his failure. E. Extent to which behavior of the party failing to perform, or offer to perform, comports with standards of good faith and fair dealing. Courts will also try to prevent forfeiture by finding partial breach. In order to prevent forfeiture, finding that K is divisible. Step 3. What will happen if there is a material breach? 243 possible future scenarios after a material breach has occurred. 1. The material breach can be cured. 2. The material breach can be waived. A waiver equals intentional relinquishment of an own right. B. Election equals special kind of waiver that takes place after performance has passed and the breach could be cured. 3. The material breach can be transformed into a total breach. A. Generally, a material breach will ripen into a total one if enough time occurs without the material breach being cured. R. Second 243. Under R. Second 243, the breaching party's breach does not give rise to a claim for damages for total breach. However, acceleration clause in the loan documents providing that if the debtor misses 2 or 3 installments in a row, the debtor agrees that the entire debt is accelerated and is thereafter immediately due and owing. Step 4. Sometimes material breach can discharge. 242. Circumstances significant in determining when remaining duties are discharged are those stated in 241b. Extent to which it reasonably appears to injured party that delay may prevent or hinder him in making reasonable substitute arrangements. C. Extent to which agreement provides for performance without delay, but a material failure to perform or offer to perform on a stated day does not itself discharge the other party's remaining duties unless circumstances indicate that date is important. A. However, if putting a time of essence clause, then it will tilt to injured party's favor. Can you get punitive damages, market damages, etc.? Step 5. When you have total breach, what remedies can you get? Total plus R. Second 242 considerations. Total breach. Material breach becomes total when injured party notify breaching party that they are declaring total breach and that 1. Not reasonable to make injured party wait any longer, or 2. Not cured. Repudiation. When one party is in material breach and subsequently repudiates the K, then the injured party may declare total breach and get damages accordingly. When injured party fully performed his duties under the K and that the breaching party's only obligation is to pay $ in installments, injured party cannot declare total breach. They may just bring suit to recover the installments as they become due, even if the breaching party has repudiated the K. O. Acceleration. Remedies. Expectation. Reliance. Restitution. Specific performance. Step 6. Only partial breach. What would happen? What constitutes a partial breach? A. Trivial. B. Not material. C. Substantial performance. Consider A. The relative fault of the breaching party. B. The nature of the defects. C. Details of the K. Remedies. Injured party can sue. Cost of completion. Cost of completion damages will usually be awarded unless they are so extreme that they would unduly compensate the injured party. Market damages. If COC damages are too high, the injured party will be awarded the difference in the market value of the performances completed and the contract price. 237. Except as stated in 240, parties must render performances to be exchanged under an exchange of promises that there be no uncured material failure by the other party to render any such performance due. Jacob and Youngs Incorporated v. Kent. Construction of house with wrong brand of pipe. Cardozo says it's not a material breach, but only partial breach. B/C contractor has substantially performed. Cardozo makes a distinction between the unintentional transgressor and a deliberate mistake. Cardozo also said where there was substantial performance of the contract, coupled with an inadvertent breach, the general damage rule that the innocent party is entitled to the cost to remediate the property as the measure of damages would be suspended when the value of the repair was economically disproportionate to the economic benefit received from the repair. Difference between the value of what was promised less the value of what was received. Sackett v. Spindler. Spindler agreed to sell newspaper to Sackett. Sackett never paid up. Sackett's disregard of Spindler's anticipatory repudiation meant that he still had to pay. Flatt v. Schupf. 205 Breach of the implied duty of good faith no longer needs to show traditional but for cause. Failure to try is the but for not satisfying the contract. Anticipatory repudiation, a declaration by the promising party to a K that he or she does not intend to live up to his or her obligations under the K. Damages, U2-713, 1, M, measured at the time when the buyer learned of the breach. Learn of the breach majority view, when repudiation is accepted, or within a commercial reasonable time. Injured party may bring suit immediately against the repudiating party. Can you bring an injunction in this case? I will not give you the money when it is due. Purchase something in 2 months, but now with a fixed price. Acceptance. unequivocal, unambiguous final total breach statement makes it insecure calling on you exceed THNK its repudiary could say it's final. More not quite clear request for a DEEC weighted. UCC is the same. 2 to 609, 610. Step 1. How can an anticipatory repudiation be established? If you can say that is okay, then you are able to say it's a material breach or partial breach. 253 Anticipatory repudiation, that is unequivocal, creates total breach questions to ask. 1. There must be a bilateral contract with executory duties remaining by both parties. 2. The repudiated duty must amount to a total breach if it is never performed. 3. The repudiation must be definite and unequivocal. 250. Anticipatory repudiation requires that the verbal/written repudiation be clear or unequivocal, or a clear and unequivocal act that indicates repudiation by conduct. Whether an anticipatory repudiation occurred is a question of fact statement. Doubtful and indefinite statements that performance may or may not occur are not enough. Affirmative act. Voluntary affirmative act that renders obliger unable or apparently unable to perform without such a breach will constitute a repudiation. Requirements. Conduct must indicate performance is impossible or apparently impossible. Step 2. When will failure to give assurance constitute repudiation? What can you do? Ask. UCC 2 to 609. 1. Demand of assurances. If 1. Reasonable grounds to believe that obliger will commit a breach that will give a claim for total breach, then oblige may demand 2. Adequate assurances of performance. For instance, bond/credit letter. Question on assurance of performance. Can the party demand what type of assurance it gets? Partially finished contracts. Needs mitigation. M. Reasonable grounds. Significant financial difficulties. Failure to perform important obligations under this K or under related Ks. Rumors. Speculations are not enough. M. Wall Street Journal. Credit statement on the counter. Suspend of the performance. What can you do about it? Remember, this is a total breach. 2. Suspension of performance allowed. Obliger may suspend any performance for which he has not received exchange until he receives assurance, if it is reasonable to do so. 3. Repudiation. If obliger does not provide assurance within a reasonable time that is adequate under circumstances, oblige can treat this as a repudiation. UCC. Approach. How to measure under UCC 2 to 609. Reasonableness with merchants. This will be determined according to commercial standards. Anticipatory repudiation is justified if a party has reasonably grounds for insecurity about the other party's ability to perform, and the party cannot give adequate assurances. After you ask for a first assurance, you must show that circumstances have changed to be able to ask for a second assurance. In Hornell, the nature of the sham operation was revealed. Hornell Brewing Co. v. Spry, Arizona Iced Tea Scam Man W/Sham Distributorship Company. 4th Damages. Damages may be assessed as a remedy once total breach is established. 3 types. 344. 1. Expectation damages. Forward-looking remedy. Fulfill the contract. 2. Reliance damages. Backward-looking remedy. Unwind the contract. 3. Restitution damages. Must reimburse value of given benefit. 4. Equitable remedies. Specific performance. Injunction. Expectation damages. Expectational damage formula. 347. It equals LVP plus OL. CA. LALVP equals lost value of performance. Direct loss. Other loss equals incidental and consequential costs generated by breach. Cost avoided equals any payments received from the breaching party. Loss avoided equals any costs saved as a result of the breach. Not need to pay things like license fee, etc. LVP. Illustration. Roche v. Bray. Mom and dad didn't pay up to kids in real estate sale, so kids had to sell elsewhere where sale of real estate is made within reasonable time after breach. Sale price is evidence of market value at the time of breach. Handicapped Children's Edition. Board v. Lucas Suski. Duty to replace teacher W/1 of equal value. Cost to completion or diminution of market value. 348. Alternatives to loss in value of performance. 1. If breach delaying use of property and the loss in value to the injured party is not proved with reasonable certainty, he may recover damages based on then rental value of the property or on interest on the value of the property. 2. If breach results in defective or unfinished construction and the loss in value to the injured party is not proved with reasonable certainty, he may recover damages based on a diminution of market value, or b. cost of completion, if the cost is not clearly disproportionate to loss in value to him. Asterisk 2b. We do take personal non-economic value into account. Always remember that Leproff thinks 1. Personal value should be taken into account, and 2. Situations real estate contracts. When a K for sale of land is breached, the injured party can recover difference between the K price and the market value of the property at the time of breach. Breach by buyer. Seller must show that the market value of land at the time of breach was less than K price. O. Resale price. In any cases, the resale price will be evidence of the market value of the property. If the resale takes place within a reasonable period of time and the resale is fair. Breach by seller. Buyer must show that the market value of the land at the time of breach was more than the K price. Employment contracts breach by employee. If employee breaches an employment K, the employer may recover the difference between the $sign they have to pay a replacement of similar qualifications and the $sign they would have had to pay the breaching employee. O. Similar qualification requirement. Employer must make reasonable effort to find a replacement who has similar qualifications to the employee that breached the K, but if a similarly qualified replacement cannot be found with reasonable effort, the breaching employee may be liable for the higher salary the employer has to pay to the replacement employee. O. Disgorgement of profits theory. Some scholars think that the market value theory used for real estate K should apply to employment Ks in order to disgorge an employee of any benefits they receive from breaching the K. Apply this when you get EDS, Movista, when there has been an opportunistic breach. M. Not majority rule. Breach by employer. When the employer breaches an employment K, the employee is able to recover damages for lost salary for the duration of the K, offset by the $sign they make in a new job, but employee must make reasonable effort to find a new job. Construction contracts breach by builder. Incomplete construction is cost of completion v diminution. 1. Cost of completion. Damages may be measured by the reasonable cost of completing performance if that cost is not clearly disproportionate to the probable loss in value to injured party. 2. Diminution in market value. If the cost of completion will result in unreasonable economic waste, then the damage is determined by the diminution in market value of the property from what it would have been if the K had been performed. This is usually true when completion would entail the destruction of structures already built. PV House minority view. Posner's efficient breach theory. Pages agreed to let DD take coal off his property and DD agreed to fix the property when done, which he didn't. The cost of completion was $30 and the diminution in market value was $300. 100:1 ratio was too extreme, and therefore cost of completion was clearly disproportionate to the loss suffered. Modification agreed under duress. Modifications that are agreed to as a result of duress, including economic duress, are unenforceable. When is there duress? Improper threat, threatening to breach a contract in order to gain assent to a modification. B/C1 knows that a breach will cause severe hardship to the other party is considered an improper threat. B. No reasonable alternative. Duress will not be found unless injured party had no other choice but to agree to modification. Protesting the modification. Most courts require the party claiming duress is required to protest the modification to fulfill their good faith duty of putting the other party on notice so that the other party will not later be shocked by the injured party's intention to resist enforcement or seek redress. Breach by contractor. When the K breaches a K, many courts say that TED are measured by the builder's expected net profit on the entire K plus the builder's unreimbursed expenses at the time of the breach. Includes any $sign received from resale of materials. Lost volume seller. If the new K is an addition 1 rather than a mitigating 1, so that both breach and new Ks could be simultaneously performed, the non-breaching party is a lost volume seller, entitled to lost profit on breached contract. LVS not required to mitigate. When LVS doesn't apply. Exclusive case. LVS rule doesn't apply where Pages had to exclusively provide services to DD and couldn't enter into another K until DD breached. Personal service case. LVS rule doesn't usually apply because Pages normally could not enter into another K at the same time because they would have a limited capacity to provide personal services. Employment case. In most cases, new jobs will be mitigating unless it is a night job or something that could have been done at the same time as the previous job. Illustration. Roth v. Spec. An employer may recover ugly fountain case. PV House. Minority view. 524 opinion. Leproth think it's wrong. The difference in market value is only $300. Cost to completion is $29,000. Tribune thinks the 100:1 ratio was too extreme. Therefore, cost of completion was clearly too disproportionate to apply. Covenant is not material, it's just an incidental covenant. Majority didn't give any consideration to the personal value. Leproth thinks it's a bad result because personal value should be taken into account. Leproth thinks he doesn't think the buyer should not run away. American Standard v. Schechtman. Leproth thinks this is also quite wrong. Other loss comes in two flavors. Incidental damages and consequential damages. The plaintiff can only argue for fair compensation. He cannot argue for punitive damages. Incidental damages. Costs incurred in trying to mitigate damages. Mitigation costs. $sign spent for ads and hiring an agent in an attempt to wrestle property. Consequential damages. Foreseeable, more likely than not outcome of the breach. The injurer has reason to expect. Lender case. When the lender promised to make the loan, they had the reason to know that no one else is going to approve the loan. Proximate cause test. But for certainty, are we reasonable certain that there will be some form of profits? Bella Rose did well later after GTE was fired. Pauline's Chicken v. KFC. Breach of franchise agreement. Nearby franchise and the franchise is managed by Pauline's Chicken plus manual says every KFC should be exactly the same. Court says yes because two benchmarks enough exist. Rutherford. Fantasy school case. Surprisingly flexible. Looking at comparable schools opened by comparable celebrities. Fine. Is there some evidence suggest the range of how much the potential profits will be? Does the jury verdict fall within that range? Oh, new business rule. If the business is new, and there is little to no record of profits, most courts deny recovery as a matter of law. Difficult to establish future lost profits. Contemporary Mission Incorporated does not allow extrapolation of the concert tour. There was no track record. There were too many unknown factors. Particularly, in the entertainment situations, it's all about audience's reaction. However, for their records, they got something, because there were track records. Sometimes you can get damages on reputations. However, generally UK court is more likely to grant them. Redgrave v. Boston Symphony Orchestra, BSO damaged Redgrave's reputation to acquire other business opportunities. Loss of business opportunities. Yes, damages. Prudential concerns might play a role in deciding the damages. If the case is Google versus Brooklyn Bodega, it is quite unlikely that consequential damages will be awarded to Google. Can make the argument. Note, if there is a notice period allowing you to terminate the contract, then you can only collect the profit fall within the notice period. Osborne, the injured party can collect only 30-day of profits, because the breaching party has the right to terminate the K after giving 30-day notice. Modern test for damages 351. 1. Damages not recoverable for loss that party in breach did not have reason to foresee as a probable result of the breach when the contract was made. 2. Foreseeability standard. Loss may be foreseeable as a result of breach if it follows from breach in the ordinary course of events. B. As a result of special circumstances that party in breach had reason to know. Objective standard. Foreseeability based on what a reasonable person would have foreseen under circumstances of the case. 3. Court may limit damages for foreseeable loss by excluding recovery for loss of profits, by allowing recovery only for loss incurred in reliance, or otherwise if it concludes that in the circumstances justice so requires it. 351. 3. If the damage, contract value, then the court might have some reservation. 351. 3. Frank recognition of the judicial reluctance to award damages that are disproportionate to the consideration paid isn't traditional, though Leproth has never seen any case applied this rule. UCC 2-715-1. Incidental damages 2. Consequential damages. Illustrations. Hadley v. Baxendale. English case establishing foreseeability as a restriction on expectation damages. Leproth thinks this is right. Court sets out two general categories, those arising naturally, and special damages. For special or consequential damages, the special circumstances must have been communicated by the plaintiffs to the defendants when the contract was made. In this case, each mill has a spare shaft per trade usage. Judge thinks that someone running a Millson's shaft can be said to be negligent. Florifax Intel v. GTE. GTE breached contract W/Florifax to provide telecommunication services. Lost profits from a collateral contract may be recovered as a proper element of damage for BOF K. Evidence of lost profits was adequately shown to a reasonable certainty, so damages were appropriate. Florifax's cost of creating a new call center can fit either into LVP and incidental damages. Foreseeability. GTE knows Florifax's K with Bella Rosen contract provision expressly allows for the recovery of lost profits in the event of termination. Certainty and causation. Mitigation of damages. Mitigation of damages. Predominantly LA. If you fail to use reasonable efforts to mitigate, your recovery can be reduced by the amount of the loss you should have avoided. 350. Avoidability as a limitation on damages. 1. Except in subsection 2, damages are not recoverable for loss that the injured party could have avoided without undue risk. Burden or humiliation. A. Employment K. Personal service K. Dignity/reputational damages are being taken into account. Employer. Revenez Vas. Jevals and Brie. Employer can say, non-mercy. 2. The injured party is not precluded from recovery by the rule stated in subsection 1 to the extent that he has made reasonable but unsuccessful efforts to avoid loss. Cost avoided. Rockingham County v. Luton Bridge Co. Once a K has been breached, non-breaching party must stop performance and they cannot recover for $on continued performance after the breach. However, if the bridge has almost finished, to finish entirely, it might get a much better value. Worth considering. If they were just giving the support so that the bridge can be built later might be okay too. Just enough to preserve the structural integrity of the structure. Loss avoided. Duty to mitigate by finding a new job or trying to wrestle the land. Burden of proof on DD to show reasonable effort. That Pages didn't make a reasonable effort to get a new job/wrestle the land is on DD. DD can show that you didn't try your best to get the best price. Learn from Donald Trump. Doctrine of comparability. Don't have to accept a replacement job unless new job gives you comparable responsibilities. Income from another job will be deducted from your teaching income. Additional job issue. If you take a new job, it will mitigate damages, even if it is not comparable, unless you could reasonably have done both job at the same time. Gianetti v. Norwalk Hospital. Pages, as a general proposition, could have continued to perform his K with the defendant hospital in addition to his Ks with the other hospitals, and therefore, the DD hospital was held to have breached its K with the Pages by failing to renew his appointment. B. BOP will be on the defendant to show that you couldn't have worked both jobs at the same time. Under UCC UCC 2-715. 2. A buyer is not entitled to consequential damages unless loss could not have been reasonably prevented by making cover or a substitute K. Lost volume seller, not required to mitigate if new contract is an additional one rather than a mitigating one, so that both breach and new contracts could be simultaneously performed. The non-breaching party is a lost volume seller, entitled to lost profit on breached K. Seller has more sell. R 350, comment D, discusses lost volume if he would have entered into both transactions, but for the breach, he has lost volume as a result of the breach. Second transaction is not a substitute for the first one, so does R 347, comment F, if the injured party could and would have entered into the subsequent contract. Even if the contract had not been broken and could have had the benefit of both, he can be said to have lost volume and subsequent transaction, not a substitute for the broken contract. UCC 2-708. 2. Lost volume sellers of goods, covers Learjet, are entitled to recover their profit. Correct formula equals unpaid contract price, market price, plus incidental damages, expenses saved in consequence of the buyer's breach. If the plaintiff is the buyer, then UCC 2-713. Learjet, 1997. The courts is convinced that have satisfied both profits, and therefore we should get both profits. LVS exceptions, doesn't apply. Exclusive case, personal service case. Gianetti, employment case. What profits? Note 4 on page 919 gross/net. Illustrations, Rockingham County v. Luton Bridge Co. kept building bridge after county voted to stop funding it. Red line in employment contract. The court said the employee should have gone back because that is not a special circumstance. Employee made the argument that they treated me so bad, I cannot actually come back. Bohm v. ABC, executive replaced and offered a lesser status, made up job. The employment cases say that you don't have to accept a job with less status than the one from which you were terminated. But what if you can't afford to sit out and you take the lower job? The lower status job salary counts against your damages. Jets Service Co. v. Salina Properties, new landlord breaches contract and makes Jets remove machines. Court holds that Jets sending the machines elsewhere was not mitigating of damages, but constitutes lost volume. B/C. It had numerous machines and could have gotten profits from both initial lease and later lease, not a replacement/substitute, but in supplemental. Parker vs. 20th Century Fox, court holds that 1. Not being number 1 star and 2. Losing artistic control counts as a big difference. People X. V. Johnson, 1968, liquor store job, works at night. He could have done both. Copland v. Faulkner, not an offset because they 1. Have additional resources, money, to build new oil rig and hire more crews, and cold done a better job. Therefore, they cold done both projects at the same time. Not recoverable cost. Attorney's fees. Attorney's fees. Each party bears own fees for litigation, unless there is a statute, court rule, or provision allowing injured party to recover them. Contract provisions. Most courts will uphold provisions in case allowing for attorney's fees. California considers these to be reciprocal. If one party is entitled to attorney's fees, then the other party is as well, but this is a minorities approach. Statute, civil rights, and T. American rule, no fee shifting, as opposed to civil law countries in which loser pays. Some statutes authorize recovery of attorney's fees, civil rights, consumer protection, etc. Parties can also provide by contract for recovery of attorney's fees. Zapata Hermanus Sousa v. Hearthside Baking Co. Cookie-tin dispute between Baker and Maker. Are attorney's fees recoverable under CISG, either as compensatory fee damages or punitive damages? No doubt that there was a breach, but court finds that 1. CISG does not authorize attorney's fees under Article 70 for loss, and 2. Attorney's fees are not recoverable as punitive damages, or there is no relevant treaty, so court uses choice of law rules, and uses IL law outside of insurance. Plaintiff must show that the breach involved tortious misconduct, such as duress or fraud, to recover punitive damages. Can't call bad faith damages attorney's fees. Posner says that when you enter into a contract, you obtain an option to break the contract and pay compensatory damages. Unlike a tort, there is no wrongdoing that requires punishment. Not recoverable cost. Mental/emotional disturbance. 353 types of contracts where breach may lead to emotional recovery. Agreements to transport bodies, common carrier/innkeeper, heirloom protection, misdiagnosis of ED. Punitive damages are reserved for outrageous tortious behavior, not negligent breach, since contracting parties need to predict their exposure. No punitive damages, unless there is an independent tort available. The exception is insurance companies. Bad faith by insurance company can get punitive damages. The only case the courts will grant punitive damage. 353 for breach of implied warranty of good workmanship in building a house. Recovery for emotional distress will be excluded, unless the breach also caused bodily harm or the contract/breach was of such a kind that serious emotional distress was a likely result. Ehrlich v. Menezes, Home Builder from Hell. Issue is whether emotional distress damages are recoverable for the negligent breach of a contract. To construct a house, court says that you cannot recover emotional tort damages for negligent breach without a physical injury, but yes for intentional or reckless. Court also says that foreseeability alone is not enough to recover for emotional distress negligent. Breach damages, because it would significantly drive up housing costs. Outside the insurance context, a tortious breach may be found when 1. The breach is accompanied by a traditional tort, that is fraud or conversion, to the means used to breach the contract are tortious, that is deceit, coercion, or 3. One party will cause severe unmitigatable harm in the form of mental anguish, personal hardship, or substantial consequential damages. 353. For breach of implied warranty of good workmanship in building a house, recovery for emotional distress will be excluded, unless the breach also caused bodily harm or the contract/breach was of such a kind that serious emotional distress was a likely result. Expectation theory. How to calculate costs that are immeasurable. Engorgement theory. Expectation damages are generally the most favored types of damages for breach of contract. Instead of focusing on plaintiff's losses, focus on defendant's unjust gains. Planning interests is sort of similar. Making long-term plans. General notion of risk allocation. Disgorgement case generally applies when there is a breach of fiduciary duty and the injuring party. Expectation theory. You had a goal in mind, and that goal was sufficient to create expectations of value that motivated the pages. Creation of reliance. Oh, where expectation damages can be calculated, the courts should grant them. Holmes says let's not focus the law on the good people, but focus on the bad people. Oh, in contracting, he sees cases involving an option to breach, and that the breach does not entail punitive consequences. Posner takes it further by arguing not only that Holmes is right but that individuals should exercise the option to breach when it would be efficient and practical thing to do. Pesnerian producer. Oh, the two parties could negotiate. Why is that a bad idea? Transaction costs.